Hi, I'm attorney Kevin Hayslett, and today I'm going to talk with you about the top 7 secrets to avoid a DUI conviction after a DUI arrest. The first thing is a traffic stop. Now, when we think of traffic stop, that means how did law enforcement get in contact with the person who was stopped and ultimately arrested? Were they pulled over for speeding? Were they pulled over for weaving? Were they pulled over because they committed a traffic infraction? Did they pull out of a bar? Did they pull out of a strip club? Were they parked on the side of the road? What was the basis? For example, if you were pulled over or someone's pulled over for weaving, just because the officer says you're weaving doesn't mean it's a lawful basis to pull you over. So the first thing you need to focus on, was there a proper and lawful traffic stop? And if the answer is no, your case is dismissed. The second thing you need to look about in these cases is the detention. That means after law enforcement makes contact with a person, a DUI stop, what was their basis to detain that individual on the scene for a criminal investigation? If that officer cannot articulate a lawful basis to detain someone on the scene, that case potentially could be dismissed. The third thing you need to focus on are the field sobriety tests. Number 1, were they done properly? Well, that makes sense. That means that most field sobriety tests, or all that we rely on in DUI investigations, have to be standardized. If they use improper instructions or they used unrecognized tests that were not authorized, or they administrated them incorrectly, all of those are basis to get the field sobriety test suppressed or get the case reduced. The other thing you have to ask is whether or not that officer had any special training. Is he a drug recognition expert? A drug recognition expert means someone who has specialized training so they can administer horizontal gaze nystagmus. That is also called the pen test. Number 4 is the breath test itself. Obvious questions are, was that officer, was he authorized, and did he have the appropriate licensing and training to be a breath test officer? If he did it 5 years ago, did he take the refresher course? Was it up to date? Because if that officer did not have the course, if it had not been re-upped, that means potentially he was not authorized to give a breath test. And if he was not authorized, you guessed it, that means the breath test itself could be suppressed, and the prosecutor, more likely than not, will reduce or dismiss your case. The other thing surrounding the breath test is the 20-minute observation period. Many people don't understand that the law enforcement officer, in order to have a valid breath sample, must be in the same room and watch the individual for 20 consecutive minutes prior to the breath test. The next thing is, these are folks for refusals. If you refuse a breath test, in order to get that refusal into evidence, the law enforcement officer has to testify that they gave you the implied consent warnings. In the state of Florida, there are specific words and wording that has to be read to an individual before his or her refusal is admissible at trial. The last thing, or the second to last thing, is a blood test. Many people don't trust breath tests. Here in the state of Florida, there's law that said if you provide a breath sample, you can request an independent blood draw. If you request an independent blood draw and law enforcement does not take the appropriate actions to help you do that, potentially the breath test can be suppressed. Lastly is the issue of driving. In Florida, the charge of DUI means that you're driving or in actual physical control of a motor vehicle under the influence of alcohol, with your normal faculties impaired, or with a blood level above a 0.08. But sometimes the issue of driving is tricky. That means, did law enforcement actually see you drive? Can they testify that you are the driver? Can they put you in the seat with the keys in ignition or the keys in your hand? Sometimes law enforcement arrive on the scene and a person is out of the car, and that person might even make admissions that they were the driver. But sometimes under the corpus rule here in Florida, those admissions would be inadmissible, and the DUI officer or law enforcement officer cannot prove you were actually driving, which is a key and essential element to a DUI case. Sometimes in accident cases, they don't observe the accident. Sometimes you'll have the emergency unit, let's say fire and rescue, or EMT will take the keys out of the ignition in a non-crash case. So when law enforcement arrive on the scene, the keys aren't in the ignition, they can't establish that you're the driver. And in the state of Florida, law enforcement has to observe all those elements in a non-crash case. So when you look and think about a DUI case, many people think that if you're above a .08 or you refuse a breath test, you got to throw in the towel, you got to admit defeat and plead to the case. But these are the 7 secrets. If you spend some time and take a look at these as it applies to your case, your loved one's case, your family's case, many times you can prevent a DUI arrest from becoming a DUI conviction.
Carlson, Meisner, Hart, and Hayslett, protecting your rights since 1971.